Well, hello again and welcome to the latest version of Mosaic Coffee Breaks. This time we are joined for the second time by Jenny Screech from the Howden Group, considering all matters to do with PII renewal come the autumn round of this year. We join the discussion where Barry Wilkinson is asking questions about the somewhat intrusive nature of the questionnaires that seem to be asked by insurers for this coming season.
Can I just ask you about on the sort of will they notice thing? One of the things that I'm hearing is that the questionnaires this year are much more detailed and more intrusive than ever before, and yet we still have the majority of the 10,000 firms renewing on the same date. Have the insurers really got time to go through all of this detail?
Yes, I know that, and the proposal forms are very long, but yes, they do. They do look at the detail on those forms. I think there's more focus in certain areas of the proposal form than others, and certainly at the moment they will be looking very closely at the business resilience type questionnaire, the pandemic related questionnaire that will look at finances. And again, that is something that's new in the last 2 or 3 years. Historically, underwriters didn't look that closely at a firm's financial position. Now the rigor that they apply to that is quite extraordinary, and they will be drilling down into that quite carefully. So yes, and we have found as a broker that things are taking longer because those proposal forms are longer. So it is taking longer for quotes to come back, and that is because underwriters are certainly making sure that they provide the level of due diligence that's expected within their organisations.
Thinking about the whole conveyancing thing, obviously with the stamp duty holiday, I think you've already identified that that's a risk. Is that going to be an area that the underwriters are going to be looking at? Did your volume go up, and what did you do to control the quality there? Because that's a claim in waiting, presumably.
Yeah, exactly. That's right. There's various issues there. The time pressure in which they did the work. Come the 30th of June last week, there's going to be some disappointed buyers and sellers out there that the job didn't get done. So we're waiting for a lot of the proposal forms to be finalised, and yes, questions around that and transaction levels. But again, what I would say to firms is, because we always encourage people to do a covering letter or a supplementary sheet to talk about some things that may not necessarily be identified from answering the proposal form. And again, it's there that I would say to people, if you've had things in place and it doesn't come out on the proposal form, take the opportunity to tell underwriters what you've done, why it's going to be different for your firm in terms of the risk profile.
I can see, Jenny, you talked about financial strength of the firms, and I can see the importance of that, because if firms are under pressure financially, they're likely to cut corners or rush things through, and that might put them under pressure and hence take risks. What about disciplinary issues? Let's say there are disciplinary issues internally or regulatory issues. Are those of relevance and significance to the underwriters?
Yes, again, that is absolutely something that that they look at, and where they request copies of decisions or correspondence, they review those issues, and same approach really as exists in relation to claims. They want to know whether this is an isolated incident that can be addressed by different approach to risk, or alternatively whether this is symptomatic of something underlying in the firm that is a concern. So yes, that again is a really important part of the part of the proposal form, and underwriters also, you know, they watch the decisions, you know, that are coming out. You know, that's why, you know, it's always really important to be very forensic about disclosing any issues that you've had from a disciplinary perspective, because the underwriter may well have, you know, picked it up from, you know, their own separate investigation.
I think it's worth saying at this point, you know, with Howden Barry here, you know, being the lawyer, is that when we do due diligence on a law firm, on a merger, if we're acting for the buyer, I always say, if there's only one document I can have, I want it to be the last PII proposal form, because that's the one that tells you the most. You know, unless they lie blatantly on it, then, you know, then you've probably got a warranty claim. But the that tells you everything. But again, what we tend to look for when we're doing our due diligence is probably similar to the underwriter. You know, is there a pattern here? You know, I've occasionally, you know, gone back to clients and said, look, if you look at that claims record, there's obviously a couple of dodgy fee earners in the whatever department. You know, there's an issue. What are we going to do about it?
Yes. Yeah. No, it's a PI proposal form tells you an awful lot about a firm, and it's the same. You know, when firms are, you know, looking at the, as you said, the merger, you know, opportunity. First thing to find out about is, you know, what the PI position is, what your insurer thinks of the proposed merger, because no PI, no practice. Yeah.
You were reading my thoughts there, Jenny, because I was just going to go on to that. We've got a long-standing client at the moment who's going through, hopefully within the next few days, completing a significant merger, and it really has surprised all of us the extent of the inquiries from the underwriters. Knowing both sides of the deal, the quality of the firm which is being acquired is very high, and yet the intrusiveness and this sort of great reluctance on behalf of the insurers actually to want to take on an extra risk at all.
You know, and particularly I think in the current environment with the concern about risk, it's something that, yes, if you are any firm that's, you know, looking to acquire another firm or looking at a merger, you know, the PI position has to come, you know, right at the top of the list to consider, because you know, you need to know whether the insurer is comfortable with it, what the premium is going to be, whether you're going to get terms at the next renewal, because that, you know, can fall apart, you know, quite badly. But I think, you know, again, insurers are looking at these things more closely than they have before, simply because, you know, they're, you know, concerned about the current claims position and potentially what might be, you know, what they might be looking at, you know, 12, 18 months down the line, depending on, you know, what happens post-pandemic.
And I'll ask a question, Jenny. Are you seeing any difference then in terms of runoff cover? Because a lot of the deals we see tend to be those firms where, if we can put this politely, they've not quite managed succession planning properly. Therefore, the way forward is, you know, to sell on to a bigger practice, who, in the hope they will then get the PI cover, etc. And that's the big driver, because they don't want to buy the runoff cover. But obviously, if there's anything dodgy, then the buyer will say, I might pay you for the business, but you've got to take out your own runoff cover because we're not becoming successor practice. Are you seeing terms change at all on runoff cover?
Yes, I mean, with that elective runoff, for some insurers, it's as per the policy, so it's simply the, you know, 3.5 times. Other insurers in the policy documentation reserve the right to calculate the premium for elective runoff. And yes, I have seen premiums, you know, at a level that would be prohibitive in terms of, you know, taking that option. And, you know, the other thing that is playing into that whole issue now is the SIF position, because, you know, the best option, you know, if you were a small firm that's, you know, looking to close, will be to go the successor practice route, because if you do go the runoff route or the elective runoff route, you know, potentially in 6 years' time, you're going to be on your own. So, you know, that is a huge.
And you know, and the firms that tend to be in this are also the ones then that are sole practitioners and partnerships. So they've not even got the limited liability to fall back on if a claim comes out the woodwork in 7 years' time.
Yes, yeah, no, that's absolutely right. And you know, we know from the data from CIF that it's more than 10% of claims are made more than 6 years after the date of loss. So, you know, that's a huge concern for people in that situation. So we've got another 12 months on that issue, but it really needs a solution.
It does. It does.
Jenny, the three questions that you've just brought to mind to me to raise. The first one is, I've always historically said runoff cover is typically 3 times annual premiums. You've just said 3 to 3.5. What is it, more towards the 3.5 or perhaps even 4? Am I out of date with my 3 times annual premiums?
Yeah, I mean, it's rule of thumb. It's between 3 and 4 times. So again, you know, it varies between insurers, but you know, I think if you said between 3 to 4, you're in the right.
I'm going to have to update my. I usually say 3, and in fact, when I'm making provisions in accounts for clients, I usually say 3 times, and perhaps this is a reason why we can make bigger provisions in the accounts.
So I mean, I think we're moving towards the end of this time-wise now, and this has been fascinating. But I was wondering whether we can ask Jenny for some nice positive news to finish our coffee break on, so we can have
just what I was thinking.
Our listeners away, with a spring, because currently it's been very slightly doom and gloomy. So, what's the good news, Jenny?
Well, the good news is, first of all, that as I said, we've still got, you know, in terms of your primary insurance, good A-rated markets available that are continuing to write this business. So, you know, that is, you know, absolutely positive news. We have still got, you know, very good cover. You know, the minimum terms and conditions are very broad. And so you have the comfort, you know, of knowing that, you know, if there is, you know, going to be a claim, that there's insurers there to respond to that, which, you know, again is positive. However, you know, I think the fact that we've still got a good pool of A-rated insurers is absolutely key, because if we were having this discussion, you know, some years back, you know, there was a different discussion going on, you know, about the risk of some of the participants in the market. So, so the insurers are still there. They're still offering terms. You know, there's nobody signaled that they're walking away from this business. So, you know, that is, you know, absolutely positive.
Well, that's good.
Well, that brings us to the end of this second session with Jenny Screech on all matters to do with PII for the renewal this coming autumn. Watch out for the next edition of our coffee breaks coming to a laptop near you shortly. Goodbye.